I'm Spencer Mazyck, and joining me now to discuss recent lockouts in Major League Sports is Proskauer's Robert Batterman. He is a senior member of the firm's sports law group and serves as labor counsel to the National Hockey League, Major League Soccer, and National Football League. Welcome, Bob. Thank you for joining us today.
My pleasure, Spencer.
So, Bob, let's begin with the recent NHL 4-month lockout that was resolved in January. But what were the main issues that gave rise to that dispute?
Well, there were two types of issues. There was the fundamental economic issue where the league, which with the union very successfully put a new system in place after the 2004-2005 labor dispute, needed to make some changes to it. The numbers didn't work. Too much had been given in player share, and it needed to be adjusted. The contract had expired, and it was time to reset it. And there were some what we refer to as system issues, matters relating to the length of player contracts, the amount of money that can be spent in certain ways, matters relating to competitive balance and the way the game is played. So there were the two types of issues, and ultimately they were resolved.
And when you say that the numbers didn't work, according to Bloomberg News, NHL had $3.3 billion in revenue last season. So under the old agreement, the players would have received 57% of that revenue, which I think would have been about $1.9 billion. Is that right?
The 3.3 is correct. The players were receiving 57% of it, and the math follows from that. Yes, and the commissioner, Gary Batterman, had done a tremendous job with his team in growing revenues from about, I believe, 2.1 or 2.2 billion over the course of that CBA to 3.3. But the 57% was too much for a number of the clubs, the lower revenue clubs, to be able to be successful as a business matter. And that can affect competitive balance, and therefore it isn't good for the sport and it isn't good for the players. So that needed to be readjusted.
Well, so let's talk about the new terms of the collective bargaining agreement. It's a 10-year deal, and I guess just based on what you said, it sounds like the players' shares were reduced. The players' share of revenues, they were reduced.
It was reduced to 50%, correct. And that's the number that our economic analysis, and I presume ultimately the union's economic analysis, said should be appropriate for the players to do well and for the clubs, if properly managed, to do well. There were never any guarantees for clubs.
So do you think the deal was a compromise for both parties? I mean, is the pension the centerpiece of the deal for the players and certainly the equal revenue sharing for the clubs?
Any good collective bargaining agreement is always a compromise.
Okay.
It's never good for the long term for there to be a winner or a loser. Collective bargaining relationship is like a marriage. It's not like a litigation, an ad hoc litigation where the parties can go at it and then go their separate ways and never have to deal with each other again. So you want compromises, and this was a compromise. There were issues that were of importance to the players, which the league compromised on and agreed to, including the creation of a new defined benefit pension plan, which will be terrific for the players. Both in terms of retirement income down the line and in terms of tax sheltering dollars under the tax codes of both countries, the U.S. and Canada. And that was important to them, and the league was happy to go along with that. And the 50% was very, very important to the league, and the union ultimately was prepared to agree to that.
Is it true that it took a marathon 16-plus hours of negotiation to reach a resolution in this matter?
It took a lot more than that. We had the ultimate session, if I remember correctly, we left at 4:45 in the morning from the hotel in which the meeting took place, after having been there the entire prior day. And then our team, the league team, took a 2 or 3 hour or 4 hour break, went home and showered and changed clothes, and met at the league office at noon, and jumped right into drafting. So
wow.
It was, and before that marathon round-the-clock session, there had been some very, very long sessions that week. So it was a a long haul.
A long haul. Well, the union director here, Donald Fear, has said that lockouts seem to be the tactic of choice for leagues, especially those with salary cap systems like the NBA, NHL, and NFL. So as labor counsel for many of those leagues, how do you respond to that?
Saying that a lockout is a tactic of choice is somewhat like saying to a surgeon that, why do you pick surgery as the tactic of choice to deal with an intestinal blockage? Under our system in this country, rightly or wrongly, when there is a labor dispute in a unionized situation, a union has a right to strike, that's its economic weapon, and an employer has a right to lock out, that's its economic weapon. The two are the same. It's just a question of who's pulling the trigger. So in the three capped sports, it turns out, in this round of collective bargaining, the leagues had all determined that they were paying too much. And if they're paying too much, they need to reduce it. If the union is prepared to agree to that reduction, then you don't need to have a confrontation. Similarly, if a union, whether players or widget manufacturing workers, want more and the employer isn't prepared to agree, then the union has the right to strike. I mean, the two are mirror images of each other. So in the three capped sports this round, there was a need, economically justifiable need, to reduce the amount of money going to the players, to increase the amount of money available to pay the expenses of running those clubs and growing the business. So the lockout was necessary as the tactic, as the weapon to force the compromise. It wasn't that the league, any of the leagues, want to lock out. It's not a tactic of choice. It's a means to an end.
Right, and I understand that, but I read somewhere that since 1994, the three cap sports, they've had a total of 8 lockouts that are related to, I guess, limiting player salaries. So that number probably isn't surprising to you since you may have been involved in them. But
it sounds high, but I'll
I mean,
accept
is it at all alarming, though?
What would be alarming, if we use that term, would be how the leagues got in the situation where they were paying more than they should have been paying. It wasn't, I don't find alarming that they found it necessary to have to bring their economics, the outflow of money, in line with the expenses and what was needed to run an efficient business.
Well, how does that happen, though?
Well, let me give you an example. In football, at the time that the basic salary cap system was designed in 1993, 94, there was one team, I believe, Miami, which had a privately financed stadium. Everybody else was just paying rent to some governmental agency or a sports authority, with no expenses to renovate, no expenses to pay off debt. Today, I don't have to tell you or your viewers how many clubs have privately financed stadiums with hundreds of millions of dollars in debt that has to be financed, where they have to spend millions of dollars on renovating or putting in new escalators or putting in new flat screen TVs in the suites or whatever it may be. Well, those expenses have to be accounted for. And if you make a split with your players where they're going to get X and you're going to get Y, and you don't take into account expenses which don't exist at that point,
those are new expenses,
but come up later, well, then you have to make an adjustment later on. With the NHL, what happened was we reached an agreement and didn't anticipate, in 04-05, and didn't anticipate that certain expenses would go up as they went up. So the 57% was too high. The league paid every dollar of it for the 7 years of the agreement. And I won't say they were happy to do so, but they certainly were willing to do so and didn't complain about doing so. But when that deal expired, it was time to reset to the appropriate number. That number, we believe, was 50%. It's unfortunate that it took a lockout to reach agreement on it, but it's been agreed, and I think the players are going to look under the old deal where the salary cap was first put in 04-05. At that time, the players were making an average of about $1.5 million a year. After that terrible battle and the imposition of a salary cap, the players are now averaging $2.5 million.
Well, yeah, someone said something like it's about millionaires fighting against billionaires just for more money. So, but what are the issues or the challenges in going up against and negotiating with unions?
Well, there are different challenges with different types of unions. It's interesting to me. I will have as clients in one industry or another, whether professional sports or not, very, very sophisticated businessmen and women. And they will come at this process and they will say, in their minds, they will say to themselves, it's another business negotiation. You know the value, you know the issue. Business people ought to be able to reach an agreement in fairly short order. No reason for a fight. What that overlooks is the fact that a union is not a business organization. It is a political organization. It is a membership organization. It has different needs, a different dynamic, and it isn't always a rational result. Collective bargaining is a different type of bargaining from a business negotiation.
Well, and I want to switch gears for just a bit because I have to ask you, how did you come to represent these national leagues?
It's serendipitous. We have a retired senior partner named George Gallants who came to our firm decades and decades ago, who represented a not very successful little organization at the time, the National Basketball Association. This was in 1966.
Oh, wow. Wow.
I came to the firm in 1966, and I started there in August with another young man by the name of David Stern. I came out of NYU, David came out of Columbia. We started working together. David started working on the NBA matters for George Gallants. Mm-hmm. David went in-house we became partners in 1974. He went in-house a couple of years thereafter. And I was doing labor law work for him.
Okay.
Those first salary cap negotiations in the early 80s, when the first salary cap in sports was designed and agreed to, I worked with him as labor counsel. He needed another lawyer in-house, and a young associate of ours named Gary Bettman went over there.
It's all starting to make sense to me.
So the best way to get to represent leagues is to have two of your lawyers become commissioners, okay? And when Gary moved over, after being number two, basically, in the NBA, moved over to the NHL in 1993, I became his labor lawyer.
Okay.
So I've been working with Gary at the NHL ever since. And then in 2007, I believe it was, Roger Goodell and Jeff Pash, Roger the commissioner and Jeff the general counsel of the NFL, and I had worked with Jeff when he had been general counsel of the NHL, met with me and asked me if I would be interested in representing them, because they had a collective bargaining agreement which was going to expire, turned out in 2011, and there were problems with it. They believed that they had agreed to too much as well, the same problem. And therefore, we had a conversation, and I was retained, and I represented them. That was my first representation of the NFL.
Well, and it sounds like the issues leading up to lockouts are typically the same, right? Does it all come down to money?
Typically, if you're going to look, the sports leagues are different from most other businesses in the sense that there is this extraordinarily important fan component. The fans are what the business is all about. And you don't lightly get into a labor dispute which is going to antagonize your fans, antagonize your players who are your product. This is a very different dynamic, and the leagues really dislike, as much as people may think to the contrary based upon what's happened in recent years, the leagues really don't want to have fights with their players. It's only when the economics force it to happen that it does happen. And that's what happened in the recent round. Hopefully it'll be decades before it's necessary again. But you know, these resets happen in collective bargaining.
And why do you think that Proskauer Sports Law Group has been sort of deemed as by many folks, the go-to practice for all sports-related matters?
Well, when you have top quality lawyers, which is what our firm has always been about in every area, it's the lawyering. That's what we do, and that's what we focus on. And when you get involved, as we originally did, on the labor piece, representing the NBA and then the NHL and then Major League Soccer and then National Football League, it gives you the opportunity, if you do a good job, to expand that work for that client into other areas. Joe Lassesi, who's now the chairman of our firm as well as the co-chair of our sports law group, is the go-to transactional lawyer in the sports field. If you're going to buy a team or sell a team or build a stadium or refinance, you go to Joe. So it spreads. Brad Ruskin is the go-to litigator, and it grows out of each of those interactions gives you another interaction and exposure to another team and another league.
Well, we wish you continued success. Thanks so much for joining us today.
My pleasure. My pleasure.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.